Welcome to your favorite legal podcast. This podcast is powered by STNZ Legal. Let's dive into today's topic. In this episode, we are going to cover some of the most frequently asked questions about the patent protection in Europe. Question 1. How can you protect an invention? Here we need to talk about 4 different routes, which are actually 4 different options for invention protection. Route 1 is the national route. You can directly file separate patent applications at the same time in all of the countries in which you would like to protect your invention. Route 2 is the regional route. A regional patent application is one that may have an effect in a range of countries. You can file one regional patent application in order to have protection in all of the members of that regional patent. European patent application under European Patent Office is an example of regional patent applications. Route 3 is the Paris Convention route. You can file a patent application in a Paris Convention country, which means one of the member states of the Paris Convention for the Protection of Industrial Property, then file separate patent applications in other Paris Convention countries within 12 months from the filing date of that first patent application, giving you the benefit in all those countries of claiming the filing date of the first application. Generally, patent applicants who wish to protect their invention in more than one country usually the first file a national or regional patent application with their national or regional patent office, and within 12 months from the filing date of that first application, which is a time limit set in the Paris Convention, they file their international application. An international application does not mean a granted international patent. You still have to make national patent applications to be granted a patent in a foreign country. Applications through Paris Convention give you claiming rights. Route 4 is the Patent Convention Treaty route. You can file an application under the Patent Convention Treaty, directly or within the 12 months period provided for by the Paris Convention from the filing date of a first application, which has legal effect in all contracting states of the PCT. The PCT makes it possible to seek patent protection for an invention simultaneously in a large number of countries by filing a single international patent application instead of filing several separate national or regional patent applications. Application through Patent Treaty Convention gives you claiming rights in the 153 member states. Do not forget to check the declarations and reservations made by some of the contracting parties before you decide your roadmap. The granting of patents remains under the control of the national or regional patent offices in what is called the national phase. This is also a patent application that does not grant an international patent, so you still have to make national patent applications to be granted a patent in a foreign country. Regarding the national phase, after the end of the PCT procedure, usually at 30 months from the earliest filing date of your initial application, from which you claim priority, you start to pursue the grant of your patents directly before the national or regional patent offices of the countries in which you want to obtain them. Question 2. How can you protect patents in Europe? European patents are granted for some or all of the contracting states to the European Patent Convention called EPC. The EPC constitutes a regional patent treaty within the meaning of Article 45 of the PCT, which means that European patents can be granted on the basis of an international application filed under the PCT. In each contracting state for which it is granted, a European patent gives its proprietor the same rights as would be conferred by a national patent granted in that state. The standard term of a European patent is 20 years from the date of filing of the application. Provided that the annual renewal fees are duly paid, patents remain in force for the maximum term. Supplementary protection certificates are intellectual property rights that serve as an extension to a patent right. They apply to specific pharmaceutical and plant protection products that have been authorized by regulatory authorities. The EU wishes to provide sufficient protection for these products in the interest of public health and to encourage innovation in these areas to generate smart growth and jobs. Supplementary protection certificates aim to offset the loss of patent protection for pharmaceutical and plant protection products that occurs due to the compulsory lengthy testing and clinical trials these products require prior to obtaining regulatory marketing approval. An SPC can extend a patent right for a maximum of 5 years. According to Article 65 of the EPC, any contracting state may, if the European patent as granted, amended or limited by the European Patent Office is not drawn up in one of its official languages, prescribe that the proprietor of the patent shall supply to its Central Industrial Property Office a translation of the patent as granted, amended or limited in one of its official languages at his option or, where that state has prescribed the use of one specific official language, in that language. Please do not forget to check London Agreement, the agreement on the application of Article 65 of the EPC. Question 3. What are the advantages of choosing the European Patent Convention route? As an answer to this question, we will cover 3 main advantages. Advantage 1 is the uniformity. European patents have a uniform wording and a uniform extent of protection for all designated contracting states and offer a high presumption of validity. Patent law in the contracting states has been extensively harmonized with the EPC in terms of patentability requirements. However, as grant procedures continue to be differently structured and are conducted in parallel by several offices, the national route generally leads to national rights with differing extents of protection. Advantage 2 is the staggered fees. Processing fees in the European patent grant procedure are staggered, so at each stage of the procedure you have a further chance to decide, in the light of the completed stages, whether your interest in obtaining patent protection is still great enough to justify paying the next fee. In particular, the separation between search and substantive examination enables you to decide in the light of the European Search Report whether it is worth requesting substantive examination. Taking into account the fees levied for the European grant procedure, costs for representation by a single agent, and the cost of conducting the proceedings in a single language, a European patent as a rule costs about as much as 3 or 4 national patents. Advantage 3 is the accelerated processing. In certain circumstances, you may be interested in having your application processed faster, at the search stage or the substantive examination stage, or both. If you file a request for accelerated processing, the EPO will make every effort to reduce the usual processing times as much as it can, under the Program for Accelerated Prosecution of European Patent Applications. Question 4. How can you file a European patent application? A European patent application may be filed by any natural or legal person, or anybody equivalent to a legal person, irrespective of nationality and place of residence or business. If you have your residence or principal place of business in a contracting state, you may act on your own behalf in proceedings before the EPO. If you have neither a residence nor your principal place of business in a contracting state, you must appoint a representative and act through him in all proceedings before the EPO other than in filing your European patent application and paying the fees. European patent applications must relate to a single invention only, or to a group of inventions so linked as to form a single general inventive concept. You can file European patent applications in electronic form using the EPO online filing software, which can be obtained from the EPO free of charge. Filings using this software may be made online or on electronic data carriers admitted by the EPO. Alternatively, you may use the EPO case management system or the EPO web form filing service, which are also provided free of charge via the EPO website. More than 95% of all European patent applications are filed in electronic form. For more information, please check www.stnzlegal.com.